All right, everyone. The time is 2 p.m. We're going to go ahead and get started. All right. This is the state expedited accusations calendar. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. Today is March 21st of 2023, and I am Judge Melanie Williams. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney here at this proceeding today. All participants, this particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch this particular proceeding. Ms. Bridgewater, what is my reset date?
It is April the 4th.
All right. All those who receive a surety or a cash bond will be reset to state all purpose on Tuesday, April the 4th. Those who receive a signature bond will be reset for the notice. Mr. Bartels, I see that you still need to conduct interviews. Are you able to give the jail a call?
Correct. Good afternoon, Your Honor. How are you?
Good afternoon.
I'm in my office. I can call the jail now.
Okay, that would be great if we could go ahead and do that. And we'll try to take positions that aren't yours.
Which courtroom or the?
It's courtroom 2. Who are you missing, Mr. Bartel?
It's Mr. Hester, number 6. And Ms.
Go to the phone, Hester. Call 22392.
22392.
Yes, courtroom 2.
Okay.
And before you is position number 9. Mr. Law.
All right, thank you. Before we begin as well, is Mr. Walker by any chance on the screen today? He's probably not. Ms. McLeod, were we able to successfully handle the case of Mr. Jackson?
Yes, Your Honor, we were.
All right, thank you. I just wanted to chat. Glad to hear that. All right, we're now on position 9, the case of Jonathan. I'm sorry, pronounce the last name for me.
Lauer.
Mr. Lauer, your case is 23 CR 001679E. You're charged with battery in this case with the offense date of March the 30th. Do you understand the rights I just explained?
Let's see.
It was a misspeak, Judge. It was the offense date was yesterday, March 20th.
I'm sorry. Yes, do you understand your rights?
Yes.
All right. Mr. Howard, can I have the history, please?
The last arrest was 2010 assault, misdemeanor possession of marijuana, 2006 DUI, 2005 failure to appear. He's a resident of Denver.
Okay, thank you. Ms. Duncan, please proceed.
Yes, Jenna, good afternoon. This incident did occur on March 20th, 2023 in the area near 13030 Upper Meadow Lane in Alpharetta. The victim in this case is Gabriel Jack Bishop. First name spelled Gabriel. Jack and Bishop are common spelling in this instance. Mr. Bishop was an Uber driver who picked up the defendant to take him to a location off Milton Road. And during that Uber ride, the defendant became upset with Mr. Bishop and struck him in the right side of his face and eye area, causing visible swelling and injuries to Mr. Bishop's face. Mr. Bishop indicated to officers that the defendant was very intoxicated. We do have concern in this case about the risk of reoffense, given this defendant's history and the fact that this was a random act of violence on an Uber driver precipitated by alcohol consumption and use, according to the victim. We did get a chance to speak to him on yesterday. He stated that he is a actual Lyft driver and picked up the defendant to take him to a destination. He stated that he believed the defendant to be drunk. He said that the defendant was acting belligerent. He stated he wanted the defendant out of his car, and then he began to call the police and stated that while he was on the phone with the police, that is when the defendant hit him in the face. He indicated that he does have red marks on his face and now has a swollen eye. He indicated when we spoke to him that he would be on Zoom, so the state would like the court to sound for him when appropriate given the nature of these charges, we're going to be requesting a $3,000 surety bond for the battery, no further contact with the victim whose name is stated on the record, 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
All right, I see Mr. Bishop on the screen. Mr. Bishop, you're not required to make a statement, but if you'd like to do so, this is your opportunity. We will just need you to turn your camera on. All right, I'm assuming Mr. Bishop does not wish to make a statement. Counsel, please give me your name for the record, and please give me your recommendation for your client's bond.
Good afternoon, Judge. My name is Adam Miller. And my client, he's 53 years old. He's a homeowner. He was here for business. He works for a tech consulting firm. He lives in Colorado. There's not going to be any, the court should have no concern over my client having any contact with the victim or anyone else involved in this case. I'm retained. I don't believe from the criminal history, I don't think my client has anything for the past 13 years. I think 2010 was the oldest thing I'm aware of. No felonies. Judge asked for a $2,000 bond. And I let my client allow him to post that cash or surety. No conditions on that. As I said, I'm retained. Client will be coming to court on this case, and there should be no fear in failure to appear.
All right. Understood. Defendant will receive a $2,000 surety bond. He's to have no contact whatsoever with Mr. Bishop. Additionally, he's to have no alcohol, drugs, or weapons as a condition of that surety bond. And as a reminder, even though he plans to intend and post bail, he'll still be reset to state of purpose on the 4th of April in the event that he does not. Mr. Miller, does that conclude your business before the court today?
It does. Judge, may I have the excuse?
Yes, you may. Take care. Have a good day. Best of luck to you, Mr. Lauer. All right, who do we have next? Is it possible to do Mr. Murphy's position? Probably not. I'm not sure if, is she at ACDC?
I think I see her, Judge.
Oh, that's her.
Position 13. She's in the front row, raising her hand. Madeline Stewart.
Is it possible for us to do that position, please? All right, good afternoon, Ms. Stewart. Your case is 23 CR 001729F. In this case, you're charged with battery and criminal trespass with the offense date of March the 19th. Do you understand your rights?
I do.
All right, thank you. This is first arrest, so we'll go to Ms. Dillingham. Ms. Dillingham?
Good afternoon, Your Honor. This incident occurred Sunday, March 19th, 2023, when officers responded to a dispute in the parking lot of Kroger located at 2452 Morosco Way Northeast. There they learned that the defendant had been driving and almost hit several people in the parking lot, including the victim in this case. And as a result of that, my apologies, Your Honor, I just lost my place. The victim in this case was screaming and asking the defendant to stop driving. The defendant then gets out of the car and begins pepper spraying the victim in this case. Upon the police arrival, they learned that the defendant had also kicked the Kroger doors off of their hinges, causing the door to break. And when asked if the store and the victim in this case wanted to press charges, they stated yes. So for that reason, the state in this case is asking for a $4,000 surety bond, a stay away from the Kroger located at 2452 Morosco Way Northeast.
All right, thank you. I'm sorry, Ms. Dillingham, was there a name of the victim?
Yes, Your Honor. One moment.
Showing that it's a Marika Short.
Okay, thank you,
Marika
Ms.
Short, and I do
Short.
believe she's on the Zoom today.
Okay, Ms. Short, if you're present and like to make a statement, this is your opportunity to do so. I don't see a Marika Short. All right, hearing and seeing none, Mr. Murphy, please proceed.
Thank you, Judge. Ms. Stewart is present before you. She's 22 years old. She resides at 1235 Woodland Avenue. That's in Atlanta, Georgia. Just, I'll get right to the gist of it, Judge. We have no issues with the stay away from that location or stay away from the victim. My client does not know who that person is. Obviously, she maintains her innocence. We look forward to looking at the evidence. We believe that this is a self-defense type situation. Obviously, that's going to take some time before we get to that point. She has no history. She's never been arrested before. Her mother is sitting right next to me in my office. She has a very good family support system who lives less than a mile away from her. So we are asking that the court issue a bond in the amount of $2,000 surety bond with no issue with any of the conditions that the state previously mentioned.
All right, at this time, defendant will receive a $2,000 surety bond, broken down $1,500 for the battery, $500 for the criminal trespass. She's to have no contact whatsoever with Ms. Short and stay away from that Kroger located on Roscoe Way. Additionally, she's to have no alcohol, drugs, or weapons as a condition. Is there anything further from either party?
Nothing further from the
Your Honor.
defense.
All
Thank you,
right.
Judge.
Does that conclude your business, Mr. Murphy?
It does, Judge. May I be excused?
Yes, you may. Take care.
All right.
Have a great
Take care. Have a
afternoon.
great day.
You too. All right, who do we have next?
Position 4.
That's still PD Bartel's
Oh, that's
case.
Mr. Bartell's case.
Yes.
Can we go to another position? I see.
Sorry about that, Your Honor. I can go
Oh,
ahead.
you're back? You're back, Mr. Bartels. Are you ready to proceed? Mr. Bartels, if you're speaking, we can't hear you. Are you ready to proceed, Mr. Bartels?
Can you hear me now, Judge?
Yeah. Are you ready?
I am ready to proceed.
All right, I'm sorry, we're at the case of Michelle Ginocchio. Is that correct? All right, Ms. Ginocchio, your
Right,
case
Judge.
23 CR 001735F. You're charged with 2 counts of theft by taking, with the offense dated February the 15th of this year. Do you understand your rights? Yes or no? Just you can nod yes or no because you're muted. That's fine. Thank you. This is first arrest, so we'll go to Ms. Duncan.
Yes, Your Honor. In this instance, the defendant was an employee of the Home Depot located at 5950 State Bridge Road in Johns Creek. This defendant was seen on surveillance video on several occasions returning lumber to the store that was purchased with a financial transaction card and initiating a refund for the United States currency amount valued for that lumber, taking that refund with the card and taking the lumber that was supposed to be refunded and placed back in the store, back out of the store. So she was taking lumber and the misappropriated refund at that time. We are aware that this defendant does have no criminal history. For those reasons, Your Honor, the state is amenable to a $3,000 signature bond through pretrial services, $1,500 per count. No alcohol, drugs, and weapons, no further violations of Georgia law, and a theft class.
All right. What was the approximate value of the lumber?
It was $116 and some change.
Okay. All right, Mr. Bartels, please proceed.
Yes, Your Honor. Thank you. I have spoken with Ms. Ginocchio. She is 59 years old, as the state stated. She appears not to have any criminal history at all. She does have ties to the community. Her ex-husband, with whom she does have an amicable relationship. Her mother lived in the Metro Atlanta area. She actually cares for her 80-year-old mother who lives with her. She does have a job. Well, she is not employed at Home Depot at this time, but she also works full-time at Perimeter Church. So given all of that, we would concur with the recommendation for a signature bond.
All right. Defendant will receive a $3,000 signature bond through the jail, $1,500 on each count. She is to stay away from that Home Depot location and have no alcohol, drugs, or weapons as a condition of that signature bond. Is there anything further?
Nothing further from the state.
All right. Best of luck to you, ma'am. Who do we have next?
Position number 8.
All right. Are you Hannah or Hannah Kang?
Yes, hey, how are you?
All right. Good afternoon. Your case is 23 CR 1725J. You're charged with having a license required to sell or distribute alcohol. 2 counts of that with the offense date of the the 3rd of March and the 25th of February. Do you understand your rights?
Your Honor, Michael Sterling on behalf of Ms. Kane.
All right, thank you. You understand your rights, Ms. Kane?
I do.
All right. Mr. Howard, can I have the history?
For Kang,
Yes.
first arrest.
Okay, thank
This
you. I
is
wasn't
SOB
sure.
jail.
All right, thank you. Ms. Dillingham?
Yes, Your Honor. On March 3rd, 2023, the License and Permits Unit, along with Zone 5 officers, uncovered that the location 848 Peachtree Street was selling and furnishing alcohol without a proper permit. Upon this search and seizure, after receiving a warrant, they were able to recover 364 bottles of alcoholic beverages seized, and their investigation determined that specifically on February 25th, 2023, as well as March 3rd, 2023, this defendant was selling alcohol. She is the owner of this establishment without a license. For those reasons, Your Honor, we are aware that this defendant does not have any criminal history, so the state is going to recommend a $2,000 signature bond. That's $1,000 on each count. A stay away order for the 848 Peachtree Street during this investigation. We ask that she does not sell, operate any business where alcohol is sold.
Okay, so 848 is her business, correct? That's the
Yes,
state
sir.
election. And it's a restaurant, or what type of business is it?
It appears to be a restaurant
Okay,
or lounge.
okay. Okay, Mr. Sterling, please proceed.
Yes, Your Honor. Judge, I represent Ms. Hannah Kane, who's a local business owner and entrepreneur, has several businesses in the Atlanta area, has strong ties to the community, has operated local businesses for quite a while. Ms. Kane has no prior arrest, Your Honor, and prior to this investigation, she's represented by transactional lawyer, by another attorney who works with her on her liquor licenses and permits. She did have a temporary liquor license at this location and has been working towards getting the permanent license through the advice of her other attorney and counsel throughout the entire time she's owned and operated the restaurant. While I would agree with the signature bond, Your Honor, I would say that she should still be able to operate her restaurant and should be able to continue to go through the process as she's represented by counsel to get her liquor license. So I believe that as long as she complies with the restrictions that she's not selling alcohol at the location pending the approval of a permit, I believe she should still be able to operate the business because it is a full service restaurant, Judge.
Okay. All right, at this time, Ms. Kane will receive a $2,000 signature bond through the jail, $1,000 on each count. She is to have no alcohol, drugs, or weapons herself, and furthermore, she's not to work at any restaurants where alcohol is distributed. However, I will not restrict her from operating or running the address or the location at 848 Peachtree Street. If she does have a temporary permit there to distribute alcohol, she can do so. All right. All right, Mr. Sterling, does that conclude your business?
It does, Judge. May I be excused?
Yes, you may. Have a good
Thank you.
afternoon. Take care. Best of luck to you, Ms. Kane. Who do we have next?
Position 1,
All right, are you Jason Banks?
Yes, ma'am.
All right, Mr. Banks, your case is 23 CR 001730D. You're charged with simple battery, family violence with the offense date of February the 11th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have that history?
5th arrest, ag assault, battery DV, simple battery. He got first offender for that. Got an open case in Superior Court, 21 CP 196782. It's armed robbery, possession of a firearm during the commission of a felony. 21 CP 196884. That's armed robbery, ag assault, possession of a firearm during the commission. That's weird. That's all I got.
Thank you, Ms. Duncan.
Yes, Your Honor, I wanted to say for the record, in 2019, this defendant did take an offered plea to aggravated assault, battery, family violence, and simple battery, family violence in the case 19 SC 166052. Those offenses did occur against the same victim as in today's case. This defendant did just recently get off probation for strangling this particular victim. The victim in this case is Lauren Bishop, both common spelling. This incident occurred on February 11th, 2023 at 980 Howell Mill Road. Officers arrived and they spoke with Ms. Bishop, who indicated that she was physically assaulted by the defendant. She had allowed him to live with her for a little while because he was trying to get on his feet, but she gave him several rules that he was supposed to follow while living with her. It became aware that he was not following the rules that she had set for her household, and she told him that he had to leave. And at the time that she told him he had to leave, he got irate and became physically abusive with her. He grabbed her and threw her around the room, and he also grabbed her and slammed her head into a wall. She indicated to officers that they have had over 10 incidences where he has become physically violent while dating her when they were living together at a different address. She advised officers that he pushed her into the bedroom wall and flung her around and then fled the scene. It's indicated here, as I said before, he just got off probation for strangling this particular victim. So we do have some concern about the risk of reoffense. We do have some concern about the danger to this particular victim in this case, given that he does have a previous aggravated violent conviction against this victim. I wanted to state that in that 2020 open case, he did receive a $30,000 good bond, but it was a different victim. And in the additional open case for robbery and aggravated assault, it was a different victim in that case as well. But he received $165,000 good bond. Since then, the defendant has been out on bond and has committed these offenses, which are also violent in nature. And it is for those reasons that the state is going to be requesting a $7,500 surety, no further contact with Lauren Bishop, stay away from the incident location, which is 980 Howell Mill Road. 2 weeks of anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law. Our office was not able to make contact with Ms. Bishop. However, we would still like the court to sound for her just in case she is on the call.
She is here. She's here.
All right, Ms. Bishop, if you're here, I need you to unmute your screen so I can place you under oath.
Yes, I'm here.
All right, you would need to turn on your camera so we can identify you.
I'm here.
All right, if you wish to make a statement, please raise your right hand. You are not required to make a statement, however. Do you wish to make a statement?
Yes, I would like to say that.
Wait. Raise your right hand.
I'm sorry.
All right, raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Please proceed.
Yes, I would like to call and I would like to say that the police call on 980 Howell Mill Road on February 11th, that was done by my mother. That situation, it was just an argument. Now, the story that the police officer had, it was extremely fabricated because my mother called. So he's getting secondhand information from my mother who lives in Kentucky. She was not at the scene. She was not present at all.
Okay, Ms. Bishop, what I'm most concerned with, I'm going to let you continue. I'm most concerned with whether you wish to have contact with the defendant. Do you wish to have
Yes,
contact?
I would. I recently got a pregnancy test. And I don't think it'll be best for us. I don't think that is best judgment to have no contact.
Okay.
Your Honor,
hold on one second, Ms. Bartels. Is there anything else you'd like to tell me, Ms. Bishop?
Not at this moment.
All right, thank you. Please proceed, Mr. Bartels.
Your Honor, I was just going to indicate to the court, I did talk with Ms. Bishop earlier. In favor of a no further violent contact order.
Mr. Bartels, your sound is going in and out again. Perhaps.
Can you hear me now?
I can. You get
I did
louder to
talk,
the beginning, and then you go out. Go ahead.
Talked with Mr. Banks. Of course, he does dispute the allegations. And at this early stage of the proceedings, he doesn't want the court to know that he turned himself in yesterday. He did find out just a couple days ago that this warrant was out for him. So he does take it seriously, his desire to address these charges and dispute them. So he did turn himself in. He has family, including cousins that live in the metro Atlanta area. He himself has been in the metro Atlanta area for 7 years, I'm told. Since 2016. I'm also told that he is employed, find my notes here. I believe he is employed full-time in the construction industry. So he's got ties to the community, he's got employment, and he is not a flight risk, we would argue, and he does dispute these charges. Given all of that, we would ask for a $2,500 surety bond.
All right, thank you.
If I may, Your Honor, just a few questions for Ms. Bishop if she's still on the call.
Very briefly, Ms. Duncan, I believe I have the flavor of this case. Is Ms. Duncan's, I'm sorry, is Ms. Bishop?
I'm still on the call.
Go ahead, Ms.
Hi,
Duncan.
Ms.
very
Bishop.
quickly.
My name is Ms. Duncan. I just quickly want to ask you a couple of questions. You stated on February 10th or 11th that your mother called the police for this occasion.
Correct.
Do you remember police arriving and you speaking to them on that occasion?
I'm sorry.
Do you remember the police arriving once she called them and you speaking to them on that occasion?
She arrived. Yes, the police arrived. I remember them. They had to get a detour.
Okay. Do you remember telling them that he flung you around the room and
No.
slammed your head into the wall?
No.
No. Okay. Do you remember indicating that you've had violent interactions before?
No.
Nothing further from the state.
All right, at this time, defendant's gonna receive a $7,000 surety bond. He's to have no contact for right now with Miss Bishop. He can return one time to 98 Howell Mill Road with a member of law enforcement to get any items. But otherwise.
Your Honor, I think that's 980.
980, I apologize, 980. This is why I usually just say the street name. The address on Howell Mill Road, he can return one time with law enforcement. Otherwise, he is to stay away. He's additionally to have no alcohol, drugs, or weapons. And again, this can be revisited at the state all-purpose calendar, whereby a provision such as the amount of bond and contact can be reevaluated. That concludes this case, unless there's anything further from the state or the defense at this time.
Nothing further from the state. Thank you, Judge.
All
How
right.
much was that?
7,000. All right. All right, who do we have next?
Position 2.
All right, Mr. Brightman, your case is 23 CR 001734G. You're charged with DUI less safe, reckless driving, speeding, driving without a valid license, and a seatbelt violation, each with the offense date of March the 19th. You understand your rights?
Yes, ma'am.
All right, Mr. Hart, can I have the history?
I think second arrest, 2013 DUI conviction. That's it.
Okay, thank you. Ms. Duncan?
Yes, I have 2 out of Georgia and 9 out of Florida. I do have a 2021 resisting officer out of Florida, 2021 possession of marijuana out of Florida, and a 2019 battery out of Florida, as well as a DUI that pre-trial has stated. This incident occurred yesterday. An officer was responding to a different incident when they visually observed this defendant speeding. However, they did not immediately go to that location because they were called to a different incident. However, upon return, they were responding to an overturned vehicle, which was the same vehicle that they had saw speeding, and it was a vehicle being driven by the defendant in this case. There were 2 vehicles involved in this accident. The defendant was going 75 in a 35-mile-per-hour zone. The defendant failed to maintain lane, struck another vehicle, which is vehicle 2, causing his vehicle to overturn and causing disabling damage to vehicle 2. The victim from vehicle two did receive medical treatment on the scene, and the defendant was outside of his vehicle. It was indicated once officers were able to get the footage from inside of the from the vehicle's electronic systems, they were able to verify that the defendant was not wearing a seatbelt, that he was in fact going 75 miles per hour about 5 seconds before the collision, and that based on the defendant's actions, the officers administered field sobriety examinations, and some of the defendant did show clues of impairment based off of the speeding that the officers observed, the verified speeding from the car's electronic systems, the collision with another vehicle, his overturned vehicle, and the other circumstances, as well as his previous DUI. The state is going to be requesting a $7,000 total surety, $4,000 on the DUI, $1,500 on the reckless driving, and $250 on each of the other charges. No alcohol, drugs, and weapons, no further violations of Georgia law, and no driving unless this defendant is going to work to see his lawyer or to medical appointments.
All right, thank you. Mr. Bartels?
Yes, Your Honor, thank you. I have reviewed the discovery and talked about this case. I did read about the speed. It appears that was the speed 5 seconds before the alleged. Given the lack of serious injury, it does appear that he was going a lot slower than that at that time. His blood alcohol level, it said it was 0.04, which is well under the legal limit for a per se. And I understand that he's not charged with per se. He's charged with a less safe DUI. But, he was able to recite, his numbers backwards and recite parts of the alphabet. And I would submit did quite well on the field sobriety test, considering that he had been in an accident and his car had overturned several times. So I understand that this isn't an evidentiary hearing, but the state, has read the allegations from the police report, and we do want to be able to respond to that. Mr. Brightman is employed. He actually has 2 jobs, one at the McDonald's and the other at the Waffle House. Let's see, I'm looking at my notes here. He is from Jacksonville, Florida, but he has been in the metro Atlanta area for several years. As I said, he works 2 jobs. And given all that, we would ask the court for a $3,000 total bond. That would be a $1,000 on the DUI and then $500 on each of the other charges.
All right. At this time, defendant's going to receive a $4,500 split bond. It'll be $225 on the DUI, $500 on the reckless driving, $500 on the speeding. Those will all be surety. That should be a total of $3,500 surety. And for the remaining counts, he's going to receive $500 signature bonds through the jail. So that should equal the total of $4,500 surety bond. Split bond. He is not to drive unless he has a valid license and he's going to and from work, medical appointments, or other official business. Additionally, he's to have no alcohol, drugs, or weapons. Is there anything further, Ms. Duncan or Mr. Bartels?
$3,500 good bond, Your Honor, and then the 1,000 SOB?
Yes.
Okay, thank you. Nothing further from defense.
That's
Ms.
what I wanted
Duncan?
to know. I just wanted the amounts. That was all.
Okay, thank you. Best of luck to you, Mr. Brightman. Who do we have next?
Position number 11, Mr. Pierce.
All right, good afternoon, Mr. Pierce. Your case is 23 CR 001726J. You're charged with criminal trespass with the offense date of March the 14th. You understand your rights?
Yes.
All right, Mr. Howard, can I have his history?
This 5th arrest. The last arrest cycle I saw was like 2011, something about driving. Everything is old.
Okay, Ms. Dillingham?
Yes, Your Honor. This incident occurred March 14th of 2023 when officers responded to 575 Boulevard, Southeast Atlanta. This was the residential property owned by the victim in this case, Mr. Jeffrey Wilson. There, the officers were made aware that the defendant had been previously evicted from that property and asked not to return, but had returned several times with the purpose of harassing Mr. Wilson. Your Honor, we did have time to speak with Mr. Wilson, and he stated that he wants absolutely no contact with this defendant, and all he wants is for him to stop returning to that location, as it has become quite.
That is not true.
Okay, 1 second, Mr. Wilson, 1 second.
Okay.
I'll give you the opportunity to speak, all right? Please don't interrupt court again. All right, please go ahead, Ms. Dillingham.
Yes, I am basing this off of the statements that were made to our victim advocate this morning by Mr. Wilson. So I do believe he is on the Zoom, and we would ask to sound for him.
So
but the recommendation in this case is $2,000 surety bond and a stay away order from that address, 575 Boulevard Southeast, and no further contact with Mr. Jeffrey Wilson.
okay. And just to be clear, this is your case, Ms. Kim?
Yes, Your Honor.
All right. After this case, is it possible for us to take Mr. Levinson's case? Mr. Wilson, I'm assuming you'd like to make a statement, so please raise your right hand and unmute your screen, please. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, I tell the truth, yes.
Thank you. As a reminder, this is not a probable cause hearing or any type of hearing where the defendant will be receiving a sentence today. However, the court is willing to hear from you. What would you like to make me aware of, Mr. Wilson?
This is not a simple criminal trespass. This is a 30-month ordeal by a person who has forged a lease and represented that he has reason to be in a property where he operated a de facto nightclub despite eviction, lease termination, and many, many complaints. We went to magistrate's court. He was found not credible in his protestations that he didn't know what was happening in the space. We won the case in magistrate court in 2021. Then he appealed to Superior Court. We won the case in Superior Court. He appealed to the Appeals Court of the state of Georgia. He lost there as well. And he and his attorneys also appealed to the Supreme Court of Georgia, where their writ of certiorari was denied. Subsequently, a writ of possession was issued by the Superior Court of Fulton County, and the marshals were called, and he was evicted from the property. It was a technicality of the writ that he had some spaces also commandeered at the time. He had never had anything more than a month-to-month lease, which he obtained by defrauding the previous tenant, by pretending to buy the business, which he never paid for. Then he told us he would not leave and not respond to lease terminations. And he also filed frivolous lawsuits in other courts. This person recently was caught on a police body cam offering a forged lease in defense of his presence in the building, which is not just theft of service. It is also in defiance of a federal court order for the sale of the building.
Section, Your Honor.
I think, Ms. Wilson, I think I've got the flavor. He's not supposed to be there. And I'm assuming you don't want him to call you. Is that correct?
No, he's actually criminally interfering in the sale of the property by contacting the buyer and representing that he has a lease. He does not have a lease, and that scares off the buyers who are there to take the property out of bankruptcy. The bankruptcy is fully a function of his presence there, operating a nightclub and driving out the other tenants. So and not only that, he has been in Georgia for 4 years and continues to present a Florida license and only lists our property as his address. So he keeps operating, and he is a flight risk from a judgment we should have against him for $85,000 in back rent.
Mr. Wilson, yes, I understand you're giving me lots of legal conclusions now, and I appreciate your perspective on this. However, the main questions the court is concerned with is I'm assuming you do not want this man to contact you, correct?
We would like him, kept in custody until we can provide further charges. There's a forgery
Okay,
charge.
okay, but that's not what I'm asking you today. The questions I'm asking is you don't want him to have any contact with you and you want him away from the property, correct?
Yes, we already had that though.
Judge,
Okay.
Judge, may I speak? Judge, may I speak? This is Louis Levinson.
Mr. Levinson, do you represent either of the parties?
Yes, I've been asked by Mr. Wilson, the victim, to speak for him. I think I can help focus. There's a lot
I
of-
would very briefly,
Your
Mr.
Honor.
Levinson.
I'll be very brief.
I think
This is a-
I think I've got this pretty clearly, but go
Right,
ahead.
Mr. Wilson's talking about civil cases. What we have is.
I am aware.
Mr. Wilson's talking about civil cases. What I want Your Honor to please consider is this man was arrested previously, and I believe a condition of his bond was that he not return to the property, and he's since returned to the property. And that is the problem that you should please consider in granting him any bond and any restrictions on those if he should be released on bond. Thank you, Judge.
All right. And as a reminder, this is a misdemeanor, so he is entitled to a bond here today. All right. I think I've got the flavor of this. Ms. Kim, please proceed.
Yes, Your Honor. I would like to raise official objection to all those comments that was totally not related to this case. Please, Your Honor, I believe you already know that. Mr. Pierce is 44 years old. He's been here in Georgia for 4 years. He has operated 3 businesses, including event company and 1 nonprofit organization for the last 4 years. He has a couple of college experience. And also, Your Honor, he claims that there was no writ of possession whatsoever, and this is illegal eviction that he is suffering from. So we would like to request for signature on bond for this criminal trespass. And yet, if Your Honor is not inclined to give him a signature on bond, we would like to keep that $1,000 bond that is already set by the magistrate court, and that's what we would like to request for. Thank you.
Okay, give me one moment. Okay, that's interesting. All right, at this
That
time,
hand raised, is it possible to make one more?
Mr. Wilson, I've got this. I think Mr. Levinson has focused the issues. Very briefly, Mr. Wilson, and if I feel you're going off the track, that'll be the end of it. What would you like to tell me?
Very briefly. We were only notified this morning that Mr. Pierce was in custody. We were preparing to swear out criminal warrants for forgery, theft, and intimidation. So
Okay, I've got it.
need
Thank you.
time to
All
do
right,
that
Mr. Wilson.
before he is let loose again. He is
Okay, thank you,
intimidating.
Mr. Wilson. Those are not, those civil matters are unrelated to the criminal trespass here. At this time, the defendant's going to receive a $2,000 surety bond. He's to have no contact with Mr. Wilson, and he's absolutely not to return to the address that is subject of this particular case. Additionally, he's to have no alcohol, drugs, or weapons as a condition. Does that conclude the business of Mr. Levinson and Ms. Dillingham and Ms. Kim? Is there anything further as it pertains to this case?
Nothing further.
Nothing further, Your Honor.
Thank you, Judge.
All right.
Thank
Take
you.
care, Ms. Levinson. See you on Thursday. All
Thank
right.
you,
Who do we
Judge.
have? All right. Who do we have next?
Position 12.
All right. All right. Are you Anthony Scott?
Yes, ma'am.
All right, Mrs. Scott, your case is 23 CR 001728Y. In this case, you're charged with battery family violence with the offense date of December the 6th of 2020. You understand your rights?
Yes, ma'am.
All right. Mr. Howard, can I have that history?
He's on probation in Gwinnett, burglary in the 2nd degree, theft by taking, first offender probation. He gets off in 2025. That's it.
Okay. All right, Ms. Dillingham.
Yes, Your Honor. This incident occurred December 6, 2020, when officers responded to 1713 Jasmine Parkway in reference to a domestic dispute. There they learned that the victim in this case, Ms. Kiana Carlisle, and the defendant had gotten to an argument. And during the course of that argument, the defendant took her phone and escalated and became physical with her. Ms. Carlisle had stated to the officers that the defendant was walking towards her in a way that caused her to think that he was going to hit her, so that she crouched into the fetal position in fear and attempting to protect herself. And as such, the defendant did start to hit her in the face while she was on the ground. The officers did observe bruising and redness to her eye from where the defendant hit her in the face. And Your Honor, we are aware that the defendant was on probation during this incident. And for that reason, the state is recommending a $4,000 surety bond, a no further contact with Ms. Kiana Carlisle, and a stay away from that address, 1713 Jasmine Parkway. I do believe she is on the Zoom, so we would ask to sound for her.
All right. Ms. Carlisle, if you're present and would like to make a statement, I need you to unmute your screen and I need you to raise your right hand. Are you present? All right, hearing and seeing none. Ms. Kim?
Yes, Your Honor. Mr. Scott is 23 years old. He was born and raised here in Georgia. He has one daughter with Miss Kiana, complaining witness here, and they are co-parenting, and they have been co-parenting even after 2020. Their relationship is friendly. It's not violent at all at this point. This was about 2 years ago, Your Honor, please. They also have another stepdaughter that they are co-parenting together. Your Honor, he is gainfully employed at Penske as a driver. He's been working there for about a month. And before that, he worked at Wendy's and McDonald's. He's been very responsible and productive. He completed up to 11th grade. And after that, right now, he's also enrolled at Continental Academy to get the certification. We would like to request for a signature on bond and no further violent contact for this incident. And yet, if Your Honor is not inclined to give him a signature on bond, we would like to definitely request for maximum $1,000 good bond. Thanks, Your Honor.
And Your Honor, if
All
I
right.
may, we did attempt to.
Hold on one second. I'm going to sound for her one more time. Is Ms. Carlisle present? Okay, go ahead, Ms. Dillingham.
Yes, I just wanted to state that we did attempt to contact her, and the last conversation that we had was that she did not want further contact. So for that reason, we would object to any no further violent contact and ask for no further contact, as well as third-party transfer of their children.
When
All
was
right,
the
because-
last interview that was done with her? I mean, if it was 2 years ago, Your Honor, it's very remote.
If she was here today, Ms. Kim, I would hear from her and make that decision. She's not here. So
Yeah.
unfortunately, it will be a no contact and he must stay away. He can return one time with law enforcement to get any items. Additionally, he's to have no alcohol, drugs, or weapons, and he's going to receive a $1,500 surety bond.
You're on the third.
Is there anything? And,
Please.
and he can arrange to see his children by coordinating with a third party.
Thank you, Your Honor.
Is there anything further?
Nothing further, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Position number 10.
All right, are you Jonathan McGee?
Yes.
Mr. McGee, your case is 23 CR 001727F. You're charged with battery and criminal trespass and damage to property with the offense date of March the 19th. Do you understand your rights?
Yes.
All right, Mr. Howard, can I have that history, please?
Second arrest, 2018 DUI dismissed. He's a resident of Illinois.
All right, thank you. Ms. Dillingham?
Yes, Your Honor, this incident occurred this past Sunday, March 19th, 2023, when officers responded to 290 Martin Luther King Jr. Drive Southeast, where the victim in this case, Miss Brittany Johnson, and the defendant reside together. There, the officers learned that a confrontation regarding something found on the defendant's phone had resulted in a verbal argument, which escalated when the defendant picked up and threw Miss Johnson's phone at her back, leaving a red mark that was observed by the officers. Miss Johnson also let the officers know that once they went back into the bedroom, he had slammed her to the bed and also to the floor and punched her in the back of the head. We did speak with Miss Johnson, and she did state that she was afraid of the defendant at the time of the incident. However, she had concerns because the two had moved here together as far as how the stay away would go. For that reason, Your Honor, we would ask for a $5,500 surety bond. That's $3,500 on the battery and $2,000 on the criminal trespass, and no further contact with Brittany Johnson. And we would ask the defendant to stay away from the 290 Martin Luther King Jr. Drive Southeast.
All right.
Good afternoon, Your Honor.
Before I go to Ms. McLeod, Ms. Johnson, if you'd like to make a statement, I need you to turn on your camera and please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I do.
All right, you can put your hand down. I'll allow you to make a statement and tell me what you'd like me to know. However, I'm most concerned with whether you wish to have contact with the defendant. Please proceed, Ms. Johnson.
Yeah, so the call wasn't called in by me, first of all, and so it may have sounded worse than it was, but like she said, the biggest thing is we moved here together from Chicago like 2 months ago. And we have talked about it. We feel like we can work out our relationship. And I did also talk to him about paying for my phone. So I'm not really sure what the trespassing portion is for, but I talked to him about, and we can figure that portion out. I feel like ourselves. And I don't feel like I don't need to be I feel comfortable with him coming back here, basically.
All right. Thank you, Ms. Johnson. I appreciate you making that statement. Ms. McLeod, please proceed.
Yes, Your Honor. My client is 25 years old. As pretrial stated, he does not have any kind of criminal record at all. He is gainfully employed. He tells me that he works in loss prevention for Macy's and has been doing that, recently since he came here. I also had the opportunity to speak with the complaining witness, and she assures me that she is not at all afraid of my client and that she does want them to continue to have contact with each other. My client does have some college education, and as I said, he is gainfully employed. He has no one else in the Metro Atlanta area except Miss Johnson. They came here together as a couple, and since she is not opposed to contact with my client, and my client does want to have contact with her, they both see it as something that was out of character, not the way they normally conduct their relationship, Your Honor. I would ask that the court give my client a signature bond so that he can get out of jail, get back to work, and also get back to working on his relationship, which is what he would like to do. And no further violent contact with Miss Johnson, which is also her wish, Your Honor. Nothing further.
All right, anything further from the state of defense?
Your Honor, I would just add that due to the fact that this did occur this past Sunday, I don't believe there has been a sufficient the state does not believe there has been a sufficient cooling off period and does have concerns for Miss Johnson's safety, and we would ask to continue with the stay away.
All right.
Your Honor, given the fact that my client has no history of violence, no criminal history at all, that Miss Johnson is on here stating that she is not in the least bit afraid of him and that she wants him to come back, I believe that there has been sufficient cooling off period. This happened on Sunday. It's not, like it happened last night. And I spoke to her at length about it.
All right.
Can I say
At this time,
also?
very quickly, Ms. Johnson. Yes.
I was just going to mention this is never happened before, like anything close to this. And which is why I didn't call the police, but also because we never had an argument this bad. So
Okay. All right. At this time, defendant's going to receive a $4,500 surety bond, $4,000 for count one, $500 for count two. He's to have no further violent contact with Ms. Johnson. And additionally, he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Your Honor, I was, given the fact that they've just come here, he doesn't really have any money. Giving him a $4,500 good bond is going to be a significant impact on his financial situation, Your Honor.
yeah.
I understand, Ms. McLeod. My ruling will stand. All right. Best of luck to you, Mr. McGee. That concludes your case at this time. All right. Is it who do we have next?
Position number 3.
All right, good afternoon. Let's see, I can barely read my own writing. Mr. Browning, your case number is 23 CR 001736B. You're charged with battery, family violence, simple battery, family violence, and hindering a person attempting to make a 911 call, but the offense date of March the 31st of last year. Do you understand your rights?
Yeah.
All right. Mr. Howard?
47 total. 2022 failure to appear, bail jumping. 2018 possession of tools for the commission of a crime. Death by receiving, obstruction conviction. He got an open false imprisonment, battery, entering also. Okay. That's it.
Okay, thank you. Ms. Duncan, please proceed.
Yes, Your Honor. When officers arrived at this location, they met with the victim in this case. I believe it's Clary Ivory Jordanian. That's CLEERE, Ivory, common spelling, and Jordanian, JORDIAN. She indicated that the defendant in this case is her stepfather. She stated that she was physically attacked by him over a gift that he wanted back. She indicated that this defendant, the defendant was on scene when the officers arrived. Ms. Ivory indicated to officers that he had bought her some shoes for her birthday, and she didn't understand why he wanted them back. So when he came into her room requesting them back, she gave them to her mother, I believe, or placed him in that direction because she did not want him to come into her room. However, that action made him irate and he began to attack her, even though she stated that she didn't want him to come any closer. She stated that he struck her on the left side of her face and her jawline with a closed fist. It's also indicated that she had several scratches on her body from the attack by Mr. Browning. She indicated that when she attempted to call 911, he tried to grab her phone out of her hand, and there was some struggle that ensued because of that instance when she was trying to call 911. Given that this defendant does have the defendant also has a dormant bench warrant case before George Porter, that's 18 CR 00519B. It is a different victim where he received a $2,500 good bond, but the charges in that case are battery, family violence, and stalking. This is a person that did live with him according to the accusations. In addition to the open false imprisonment and battery in 23 CP 21707 against Crystal Clemens, who is also a different victim, and the open entering auto, the state has serious concerns, as well as given its history with violent offenses and bail jumping and failing to appear for court. So we have significant concerns about his risk of reoffense, his flight risk, and his likelihood to respond to the legal process. It's for those reasons that the state is going to be requesting an $8,500 total surety bond. That's $5,000 on the battery, family violence, $2,500 on the simple battery family violence and 1,000 on the hindering 911. It is indicated that both parties live at the location, so the state is going to be requesting a stay away from the incident location, which is I thought I had it written down. One moment, I'll give it to Your Honor.
I have it as 1125 Fairburn Road.
That is correct. Stay away from the incident location, 2 weeks of anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law. We were not able to make contact with the victim in this case. However, we would like the court to still sound for her just in case she is here.
And the last name was Jordanian. Was
Your Honor,
that
I believe her
correct?
first name is Jordan and last name is Cleary.
Okay.
I think
Is-
that's reversed on the warrant.
All right. Is Ms. Cleary present on this Zoom conference and wishes to make a statement?
My understanding is she lives out of state, Your Honor.
I'm not seeing or hearing, so please proceed, Mr. Bartos.
Okay, thank you, Your Honor. I've looked over the discovery. I've spoken. As I'd
We're still
indicated, can y'all hear me?
We're still losing your audio every couple words, Mr. Bartel. I don't know why that's happening, but when you
I know,
stand very-
Judge. I'm doing the best I can here.
I understand.
Okay, but my understanding is that the alleged victim, Ms. Cleary, lives out of state. So a no further contact order would not be an issue. We wouldn't argue with that. He does dispute that he was the primary aggressor. Mr. Browning informs me that he had no desire to get Ms. Cleary's shoes. He said they were in a verbal dispute and she started hitting him with the shoes, which is how they got involved. So he does deny the allegations. He does have a job right now. He is set to start a job as a manager at Club Lacura. That's a restaurant and nightclub. His entire extended family, I'm told, lives in the metro Atlanta area, and he's lived in Atlanta all of his life. So he's employed. He does have ties to the community. Given all that, we would ask for a $2,500 total bond with $1,500 on the battery and $500 on the other two charges.
All right, and as to the stay away location, is that alleged to be where the defendant resides?
I believe he is residing in another location. Mr. Browning, you're living at the Mount Gilead Road address, correct?
Yes, ma'am. We no longer stay there, and Jordan stays in California.
Okay,
Right.
okay, don't say anything further. Okay, thank you. All right, at this time, defendant will receive a $2,500 surety bond, $1,500 for count one, $500 for each remaining count. He's to have absolutely no contact with the alleged victim in this case and stay away from wherever she resides. Additionally, he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further. Thank you, Your Honor.
All right, best of luck to you, sir. What do we have next?
Number 5.
All right, good afternoon, Mr. Gomez. Your case is 23 CR 001739D. You're charged with having no insurance, driving with an expired license, attempting to misrepresent a tag, giving false information, 2 counts of giving false information, and possessing a fraudulent or altered identification document. Do you understand your rights here today?
Yes, ma'am.
All right, can I have that history, Mr. Howard?
On probation, possession of marijuana with intent, possession of a firearm by a first offender probationer. In 2019, they gave him 5 years probation for that. He had a 2016 trafficking charge. That's it.
Okay. You said 2016 traffic or trafficking?
Trafficking, drug trafficking.
Oh, trafficking. Okay, that's what I
And
was.
it said conditional discharge.
Okay, thank you, Ms. Duncan.
I also saw a 2019 driving with a suspended license. In this case, Your Honor, it did occur yesterday. Officers were doing a stationary patrol in the area. And they conducted a traffic stop of the defendant's car. When they made contact with the defendant, they asked him for his driver's license. He provided them with a fictitious driver's license, and he stated to officers several times that his name was Nicholas Raymond Stinson, and he had a date of birth of September 30th, 1979. The officer looked at the photo on the driver's license and it did not match the defendant. He was then asked to place his finger on the rapid ID scanner and he was able to be identified that way. In addition to that, while on this traffic stop, officers notated that the vehicle being driven had a Texas registration plate, and that Texas registration plate came back to have no insurance and expired registration. Furthermore, during that traffic stop, the officer saw that the car that the defendant was driving had put the VIN number into the GCIC, and the registration for that vehicle also came back as expired. For those reasons, Your Honor, the state is going to be requesting a $6,000 total surety bond. That's $1,000 per count in this case, Your Honor. No alcohol, drugs, and weapons. No further violations of Georgia law, and no driving unless validly licensed, insured, and registered.
I'm sorry, Ms. Duncan, was that, did you say 6,000 you're asking for? Or 8,000?
Yes, 6,000, 1,000 surety per count.
Yes, Your Honor. I've looked over the discovery. I've spoken with Mr. Gomez. He does tell me that the car did not belong to him, that this was something that a car that he had borrowed from a friend of his. So he was not aware of the issues with the registration and the insurance. It looks like from the police report, he was allegedly pulled over for a window tint. He's not charged with that. And, I think given the amount of traffic stops that are made with that's basically a bogus pretext, this is another issue for another day, but I think he would have a good motion to suppress. But be that as it may, I'm informed that he was not aware of the problems with the tag and the insurance with this vehicle. Mr. Gomez is employed, I'm told, Your Honor. I'm told that he works at the 1145 Lounge that's on Peachtree Road in Buckhead. He is employed there full-time as a manager. And given all that, we would ask the court, well, it looks like one or two of the charges with problems with the tag and the false information may be duplicative. So we would ask for a $500 good bond on each charge, and we would ask the court to consider signature bonds on at least some of them. And that's it.
And I just want to clarify for the record, he gave a false name and date of birth, and the registration, I forgot to mention this, actually did not exist. The number that he gave for the Texas plate that was on the car, it was a fictitious registration number as well.
All right, defendant's going to receive $1,000 surety bond broken down as follows: 100 surety count 1, 100 surety count 2, and 200 on the remaining counts. He's not to drive unless he's properly licensed, insured, and the car he's in has proper registration. Additionally, he's to have no alcohol, drugs, or weapons. Is there anything further?
Nothing further. Thank you, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Position number 6.
All right. Good afternoon, Mr. Hester. Your case is 23 CR 001737A. You're charged with simple battery family violence with the offense date of June the 17th of 2021. Do you understand your rights today?
Yes, ma'am.
Mr. Howard, will you put the remote history onto the record, please?
I said, yes, ma'am.
All right, thank you, Mr. Howard, please.
15 total. 07 ag assault conviction. He had a 04 arrest for a capital offense that was dead docket. That's it.
All right, Ms. Duncan.
Yes, and I did additionally see a probation violation in 2011, as well as an open criminal damage to property in the second degree and a simple battery with a different victim. That's 23 CP 217089, as well as a couple of other capital arrest offenses, and a 2017 FTA and a 2019 FTA. In this instance, the defendant struck the victim, in this case, Kayla Mack, who is the parent of the same child as the defendant, has indicated that she was in her vehicle. He pulled up to her vehicle and there was a verbal altercation because he believed that she was talking to another male. She stated that at that time, the verbal dispute occurred and he reached into her vehicle and punched her in the arm. But officers indicated she did not have any visible injuries. Their 5-month-old child was present during this instance between Mr. Hester and Ms. Mack. For those reasons, Your Honor, we do have some concern given the risk of reoffense because they do share a child together. And this defendant's actions based on his belief that she was talking to another man are concerning for the specific safety of this particular victim. Also, given that we were not able to make contact with her, the state is going to be requesting a $3,000 total surety, no further contact with the victim, third-party child transfer, stay away from wherever she resides. I don't know if there was an address. I don't know if this is her address, but the incident location is 1245 Graymont Drive. We're also going to be asking for 1-day anger awareness, no alcohol, drugs, and weapons, no further violations of Georgia law.
Sorry, give me the victim's name one more time, Ms. Duncan, please.
Caleb Mack.
All right, is Ms. Mack present on this Zoom conference and wishes to make a statement? All right, hearing and seeing none. Mr. Bartels, please proceed.
Yes, thank you, Your Honor. I believe, Mr. Hester does deny the allegations, but I believe the location of the alleged offense, it allegedly happened in a car. So I think 1400 Venetian Drive. I don't believe that's a residence. I think that's just the alleged location where he's accused of doing this. As I said, he does deny the allegations. He indicated to me that he and Ms. Mack were having a verbal argument, and he simply took the children and left. He does have ties to the community judge. All of his extended family, including his mother, live in the metro Atlanta area. It appears that this was almost 2 years ago, June 18th of 2021. I'm also advised that he's employed full-time in the construction industry, and he also is raising 2 children. His kids are 2 and 13 right now. So given all of that, we would ask for a $1,500 surety bond. On the
All right, defendant will receive that $1,500 surety bond. He's to have no contact with Ms. Mack. He can arrange to see the children if he shares any with her by contacting a third party. Additionally, he's to stay away from wherever she resides. Additionally, he's to have no alcohol, drugs, and weapons as a condition of that surety bond. And as a reminder, he'll be reset to the April 4th state all-purpose calendar. Is there anything further?
Nothing further from the state.
All right, best of luck to you, Mr. Hester. That concludes your case. Who do we have next?
14.
All right. My page 14 cut off. Is this the Theriot case?
Yes, ma'am.
All right. Your case is 23 CR 001672B. You're charged with battery and criminal trespass with the offense date of March the 19th. Do you understand your rights?
Yes, ma'am.
All right, thank you. Mr. Howard, can I have his history as well, please?
He on probation for aggravated battery. 2019, they gave him 15 years. 2018, reckless conduct conviction. 2019, battery DV. I got a trespass as well. And 2023 trespass conviction. That's it.
Okay, thank you. All right, Ms. Dillingham?
Yes, Your Honor, this incident occurred this past Sunday, March 19th, 2023. Officers responded to the MARTA Lindbergh Station located at 2420 Piedmont Road Northeast. There they learned from the victim, in this case, Miss Nicole Levy, that she had seen the defendant talking to himself and tried to walk away, and he looked at her, started yelling explicitives at her, and then jumped her and hit her in the face, causing causing her to have a severely busted lip that the officers observed bleeding upon their arrival. The officers also conducted a search and found that the defendant had an active MARTA suspension and was in fact banned from MARTA until February 29th of 2024. Your Honor, for that reason, coupled with the fact that the defendant was on probation when this incident happened for another battery, we are recommending a $5,000 surety bond in this case. That's $3,000 on the battery and $2,000 on the criminal trespass, as well as a stay away from all MARTA locations in coordination with that suspension, and a no further contact with Miss Nicole Levy. We are aware that she did not know him prior to this, but just for abundance of caution, we would ask for no further contact.
All right, I'm gonna sound for Miss Levy at this time. Is Miss Levy present? All right, hearing and seeing none. Who represents this defendant? Is it you, Miss Kim?
Yes. Your Honor, Mr. Tarriot is 34 years old. He was in Louisiana, however, here in Georgia for more than 20 years. Phone number, and yet his residential where, so I'll be making social worker services to have a visit for him to get a housing resources, and also BHET to review his condition. He completed up to the 7th grade at the high school, and then he was referred to getting certification. However,
Miss Kim, you're breaking a little bit.
Yes.
Here we are.
Yes,
Go ahead.
my internet is not stable here for some reason. So I'm trying to connect here. Sorry about that. And he does have 3 minor children, Your Honor. We would like to request for a signature on bond since his financial income is very limited. He's qualified for public defender services. Even after this bond hearing, he even $500 good bond will be no bond for him. So we would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond because it is a violent offense, we would like to request for a maximum $1,000 good bond, and we have no objection to stay away and no further contact. Thank you.
All right, defendant will receive a $2,500 surety bond, $2,000 for the battery, $500 for the criminal trespass. He's to have no contact with Ms. Levy and comply with all active MARTA suspensions. Additionally, he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further, Your Honor.
All right, best of luck to you, Mr. Theriot.
I'm sorry, Your Honor, was that a $2,500 signature bond?
No, surety.
Surety, okay, thank you.
And what does that mean, Your Honor? What?
All right, Ms. Kim will explain it to you, okay? Thank you. All right, who do we have next?
Position 15.
All right, Mr. Thomas, your case is 23-CR001731C. You're charged with battery family violence with the offense date of March the 30th. You understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have that history, please?
2019 possession of marijuana, 2019 sale of marijuana, and possession of drug-related objects.
That's it?
Yeah.
All right, Ms. Dillingham.
Yes, Your Honor. This incident occurred yesterday, March 20th, 2023, when officers responded to 5500 Oakley Industrial Boulevard, which is where the defendant and the victim, Ms. Charlicia Covington, reside together. There they learned that a verbal argument had happened between the defendant and Ms. Covington, which Miss Covington tried to de-escalate and asked the defendant to leave to go to his mother's house, to which he refused and instead charged at Miss Covington, grabbing her by her face and pushing her onto the couch. Upon the arrival of the officers, they observed small scratches and lacerations to the left side of Miss Covington's face. Your Honor, the two do share a child together, so for that reason, the state is going to recommend a $3,500 surety bond, no further contact with Ms. Charlicia Covington, a stay away order from that address, 5500 Oakley Industrial Boulevard, and third-party transfer of that child. I do believe she is present on the Zoom today, and we would ask to sound for her.
All right, Ms. Covington, if you wish to make a statement, please turn on your camera and raise your right hand.
Yes.
All right, do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. What would you like to tell me?
First, Your Honor, in my statement, I would like to address that the officers who took my statement down was not clear about what I stated, which was to have Juwan Thomas removed from the residence at the time due to our confrontation. Once the officers got here, I was listening actively. They already had said that they were going to arrest him before even taking my statement. Then after coming upstairs, they asked, was there any physical? I said, no, he grabbed me. They said, how did he grab you? I said, he wrapped his arms around me. He asked, was he giving you a hug, like a hug? I said, yes. And then that's when, let's see, I wrote all of this down. Okay, yeah. So after that, they proceeded to take my ID. I do not agree with what the officer stated in my statement. And I do not agree that he should not be able to come back to his residence. I desire to avoid the disputes at the time and give him some time to relax and about his grief and the loss that he has taken. He just lost one of his close friends, so he's going through grief, and that's what that was about. I was not hit in the face. I was not pushed on the couch. So I'm very, very adamant about the officers that came because they already had they addressed him first before even talking to me. So I disagree with that. I can't hear you at all.
No, Judge, we can't hear you.
Okay, no problem. Okay, no problem. Yes, ma'am. She said you should be back in. I'm trying to get it done. You saying will not allow.
Good for you.
Can everyone hear me?
I can hear you.
Okay, the judge is having a few technical difficulties. Give her just a few minutes. She's trying to get back in, okay?
No
I
problem.
can hear you.
Yeah.
Okay.
Holly,
Yes,
tell the judge I'm about to run to the restroom. I'll be back.
no problem. I'll let her know.
All right, Ms. Bridgewater, are you able to hear me?
Yes, but pre-trial just left. They're running to the bathroom, so we have to.
Okay, I'm gonna have to use the sound on my phone and the video on the screen. It's a little bit of a hack. I don't know what's going on today. All right, thank you for making that statement, Ms. Covington. I appreciate it.
Can I also address that we have a 1-year-old dog together. I go to work and he helps with watching her. I don't have very much support on that end. And while he's working, I watch her. So it's like a teamwork here. So I wouldn't agree that, we wouldn't have that contact with one another.
All right, thank you.
Your Honor, if
All
I
right.
may just inquire a few questions of Ms. Covington.
Yes, very
Sure.
briefly. Go ahead.
Good afternoon, Ms. Covington. Do you remember telling officers that the defendant grabbed you and pushed you to the couch?
No, I stated that he grabbed me and he grabbed me as far as a hug. That was in my statement. And we were going into my daughter's room. I was very detailed about that and made sure that was very clear.
And if you stated that he grabbed you for a hug, why is it that you called the police?
I called the police because the confrontation was getting irate. So I did not want any of us to have to go through that. It was late at night. So, and he's grieving. So I just wanted him to go to his mom's house so that he can grieve about his loss of his friend and return home.
So you called the police because the defendant was being irate. How did you get the
Yeah.
scratches on your face?
The who?
The scratches on your face.
I have scratches on my face due to my daughter. I mean, she hit me last week. It's not even fresh. But he assumed that. He never inquired that. He just assumed that. So it was like preposterous to me, And being that you had already said that you're going to arrest him before taking my statement, how can you say that?
Okay.
It was just so much that was.
I think we've
Thank you,
clarified
Ms.
that point.
Covington.
Thank you, Ms. Covington. All right, Ms. Kim, please proceed.
Yes, Your Honor. Mr. Thomas is 26 years old. He was born and raised here in Georgia. And Your Honor, of course, they have one daughter who's only 1 year old. And she also has 10-year-old daughter. So it is very crucial for her to have a child care together, teamwork as a co-parent. Your Honor, they are still in a relationship and they live together at 5500 Oakley Industrial. And also, Your Honor, my client is full-time student as a auto mechanic.
at Atlanta Technical School, and he has been working there. And he also has a disability. He has a hard time to stand up too long and sit down too long, and yet he's overcoming that disability challenge and pursuing his academics and also taking care of his child. We would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond, we ask for $1,000 maximum bond, and also no further violent contact, as Ms. Covington stated that she's not afraid of him. Thanks.
All right. At this time, defendant's going to receive a $5,000 surety bond. He's to have no further violent contact with the alleged victim and have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further, Your Honor.
All right. Best of luck to you, sir. That concludes your case. Who do we have next?
16, Whitehead.
All right, Mr. Whitehead, your case is 23 CR 001732A. You're charged with simple battery family violence with the offense date of March the 18th. Do you understand your rights?
Yes.
All right. Mr. Howard, are you back? Yes, you're back. Can I have the history, please?
7 total. 2016 DUI, suspended license. 2016 probation. 2016 failure to appear. 2006 reckless conduct conviction.
Okay, that's good. All right, Ms. Dillingham.
Yes, Your Honor. This incident occurred this past Saturday, March 18th, when officers responded to 1901 Vesta, VESTA Avenue in East Point, Fulton, which is the residence of the defendant. There they spoke with the victim in this case, Ms. Sanquana, that is Sanquanna Whitehead, who is the daughter of the defendant. There, she explained to the officers that she and the defendant were in an argument regarding money that the defendant believed was owed to him. And after Miss Whitehead declined to pay, the defendant started pushing her out of the door towards the railing of the outside of the property. The defendant also grabbed her clothing and tossed them out of the front door. We did have a chance to speak with Miss Whitehead, and she stated that it won't be a problem for her not to go back to the residence. She stated that she does not live there, so we don't need to ask for a stay away in this case. So the state's recommendation is a $2,000 surety bond and no further contact with Miss Sanquana Whitehead. We would also ask for 1 day anger awareness.
All right, Ms. Kim.
Yes, Your Honor. Mr. Whitehead is 50 years old. He was born and raised here in Georgia. He is proud father of 4 adult children, Your Honor. He is gainfully employed at URP Construction. He's been working there for about 90 days. And he also graduated from high school, Your Honor. We would like to request for signature on bond. And also he believes that this incident is because of his daughter's medical condition right now. And yet we would like to request for a signature on bond. And if Your Honor is not inclined to give him a signature on bond, we ask for $1,000 maximum good bond, Your Honor. He has a foreign county hold, so he's not going anywhere, Your Honor. He cannot run away. He will be released to another county, and that's why we would like to request for a signature on bond. Thanks.
All right. Let's see. Defendant will receive a $1,500 surety bond. He's to have no contact with Miss Whitehead and have no alcohol, drugs, or weapons. Is there anything further?
Nothing
further.
All right. Best of luck to you, Mr. Whitehead. Who do we have next?
17.
All right, Mr. Wicker, your case is 23 CR 001733G. You're charged with promoting or organizing illegal drag racing with the offense date of October the 16th. You understand, right?
Yes, ma'am.
All right, Mr. Howard.
This is his 3rd arrest. He was arrested last year for felony fleeing an officer window tint. That's open in Gwinnett. He's wanted out of the cab on a traffic offense, and it's for reckless stunt driving.
Okay.
That's it.
All right. Ms. Dillingham.
Yes, Your Honor. This incident occurred between October 15th around 10:30 p.m. And early morning of October 16th in 2022. Officers found a group of people that had gathered for the purpose of illegal street takeovers to engage in reckless stunt driving. Amongst that event, the defendant was involved in. The officers learned that the defendant actually was responsible for creating this list of people and addresses to shut down the traffic and encourage the partakers to perform burnouts and donuts along the 900 block of Pryor Road. Part of this takeover included putting liquid flame accelerant on the ground and setting it on fire, as well as revving engines and spinning tires. Your Honor, the state is recommending in this case a $3,000 signature bond, and we would ask that one of the conditions for that bond be no drag racing or reckless stunt driving at all, and a stay away order from the 900 Pryor Road.
All right, Ms. Kim?
Yes, Your Honor, we have no objection whatsoever to the signature on bond. We just want to ask for through the jail. Thank you.
All right, defendant will receive a $3,000 SOB through the jail. Of course, he's not to engage in any stunt driving or any of this type of conduct as a condition. Additionally, he's to have no drugs, alcohol, or weapons as a condition of that signature bond. Is there anything further?
Nothing further, Your Honor.
All right, best of luck to you, sir. Don't do that anymore. All right, who do we have next?
Courtroom 1 has pleaded everyone.
Oh, additionally, let me add to that last case. He's to stay away from that stay away location on Pryor Road. I'm sorry, you said courtroom 2 is completed?
Well, Your Honor, position number 3. He wants to ask you a question regarding his charges. He said that all his charges weren't done.
Okay. 1 second. Is there an announcement for position 7?
Position 7.
That case is, I don't think it's going to be heard on today's calendar per the information I received, Your Honor. That defendant has a felony case for the offenses of a similar nature in Superior Court under 23 CP 217090. And I believe these 2 counts of reckless conduct were added in addition to the litany of charges that are a part of the Superior Court case.
Okay, so she received a bond for these charges as part of the felony first appearance?
I would like
I think that would be a conflict case.
I'm sorry, this defendant, I think the defendant was speaking, Your Honor. I'm not exactly sure. I would like Ms. Falk to chime in. I'm not sure if she received a bond for these reckless charges as well.
Your Honor, I will say because it is going to felony first appearance and went to felony first appearance this morning. So I don't know whether she received a bond on these charges or not. I know the charges were addressed at felony first appearance.
Okay.
Whether she got no bond or a bond.
Right.
Yeah.
Okay, understood. Thank you. I just wanted to make sure there was nothing we needed to do. All right, going back to position 3, you say you have additional charges, sir?
Yes, William, I think what happened this morning, I think that when I went to felony court, they had brought about those as if there was new cases. I had previously made bond on those cases, and that's how I did get the failure to appear on those cases. However, some kind of way the judge did set bonds on those cases because she called out the victim's name to me this morning. She called out
So you're saying that the cases I just heard were addressed at felony this morning as well?
No, the cases that you just addressed was the 2 new cases that I had. The 2 cases that they addressed at felony court was cases that I already had. I was out on bond for those cases. However, she reinstated those bonds. And that's what I was just telling Officer Myers when I was asking him about my bond amount. I said that she gave me bonds on all my charges. He said, except for these 2 cases. And the same 2 cases 4 cases. But the charges was the stalking, which was against Joy Lee, and the simple battery was against Joy Lee, and the other victim was Adria Denby. The judge in felony court called both of those cases out this morning. The two cases that you just called out was Crystal Clement and my stepdaughter, which is Jordan Cleary.
Okay, so you're saying there are additional felony cases that have not been addressed?
What I'm saying is there are the two cases that he telling me that I got to state court, got to go to state court for, are the same cases that I've just been in court for this morning.
I don't know that that's possible. Is any? Go ahead.
I'm sure of that.
I did try to explain it to him, Your Honor, but he said he wanted to talk to you. And
Right, I don't think that's possible, but does anybody have information about what happened in felony this morning? Is there any address?
I don't know anything about that, Your Honor, but we got a bond on this charge, and there's another misdemeanor case on.
You went
I'm
out,
not sure
Mr.
what else.
Bartels. I'm sorry. Go ahead, say that again.
I'm not sure what I could do. He did get a bond on the misdemeanor. There's another misdemeanor case on the booking screen that also has a bond from 2017. So that's all that I can address now.
Okay.
From my understanding, just to clarify that 18 CR 005191B is the Audrey Denley case. That case is in dormant bench warrant status for the battery, family violence, and stalking. In addition to that, this defendant has two open cases in Superior Court, 23 CP 217070 for false imprisonment and battery, and another 23 CP 217071 for entering auto. So those are all the cases from my understanding in my research this morning, that this defendant has the two new open cases with the 23 CP numbers and the dormant bench warrant from state court for failure to appear before Judge Porter.
Okay, so those
all of the misdemeanor cases have bonds listed, so he has bonds on all of those.
And bonds on the open
Okay, so these are different. I'm sorry, Mr. Browning. I think that you might need to clarify that with your attorney, but these are not the same cases that were called this morning and that bond for. Okay.
Can I ask you something, Judge Williams?
Very quickly.
Could they state to me what victims these supposed to be that's in state court?
I'm sorry, say that. You mean the case we just said today?
I want to ask you what victims those supposed to be in state court.
You talking about for the dormant bench warrant cases?
No.
Looks like there's a family violence battery case from 2018 and a traffic case, driving without license and then failure to yield right of way from 2017. And you have bonds on all of those cases, Mr. Browning.
What I'm asking her is because she identified the victims.
We are able to do that at this time, Mr. Browning. Why don't you give your attorney a call? I do not believe, based on what I've heard today, that you have duplicate charges, duplicate bonds, or duplicate anything. I think a bond has been set on each of your individual charges, okay? All right. Best of luck to you, sir.
Now, before I go over the calendar, I need to have some kind of, on position number 7, I need to make sure that my paperwork is correct. So what are we doing with her? We did not hear her today. I understand she went to felony earlier, but I have to document something on my paperwork before I turn it in.
Ms. Bridgewater, I can email you the email from Ms. Chanel Young stating, the Superior Court clerk stating there were additional charges of a felony nature that were related to our misdemeanor charges that the that the officer had taken out after the misdemeanor charges. And so because of that, the misdemeanors got wrapped into the felony case, and she assigned it a CP number and then sent an email to all of us. So I'll just go ahead and forward that to you. Hopefully that can resolve it for your paperwork. If it doesn't, just let me know.
Is there
Are you speaking about Ms. Jenkins?
Yes.
Ms. Jenkins,
Nobody
yes.
told me. I've just kind of been sitting there waiting for the case to be called.
Yeah, that's what we're discussing now. So do I put she's gonna be reset? Or am I gonna put she's not on that? I just need to put some kind of closure on my paperwork.
Right. So, and Mr. Jordan was also looped into this. So apparently we are closing out our case and the charges were transferred to felony court.
So is it fair to say it was transfer when you had transfer order or no?
I asked Miss Young about, she stated we didn't need a transfer order because they were hearing the case this morning in felony division. So the reason for the transfer order is so we can get it a CP number so it can be heard, but it already has a CP number.
So we received acquisitions for a CR case that we have to now close. So either a transfer or dismissal or something to close out the state court case.
Okay, then I will send that transfer order immediately. If that will close out the case. I don't want to hold up everybody for that reason. So let's go ahead and send.
Much appreciated.
No problem.
Okay, with that being said, are we now ready to go over the calendar? Yeah, I don't hear y'all, so I'm gonna go ahead and get started.
I'm ready.
Okay, here we go.
Water, please go.
Let's do it.
Okay, once again, the reset date for the SAP calendar is going to be April the 4th. Okay, position number 1 is going to the SAP calendar with a $7,000 good bond. Position 2, SAP calendar with a $4,500 split bond. Position number 3, SAP calendar with a total $2,500 good bond. Position 4, reset further notice with a total $3,000 SOB through the jail. Position 5, SAP calendar with a total $1,000 good bond. Position 6, going to the SAP calendar with a $1,500 good bond. Position 7, Ms. Falk is gonna get that all cleared up. Position 8, reset further notice with a total $2,000 SOB through the jail. Position 9 is going to the SAP calendar with a $2,000 good bond. Position 10 is going to the SAP calendar with a total $4,500 good bond. Position 11, SAP calendar with a $2,000 good bond. Position 12, SAP calendar with a $1,500 good bond. Position 13, SAP calendar with a total $2,000 good bond. Position 14, SAP calendar with a total $2,500 good bond. 15, reset to the SAP calendar with a $5,000 good bond. 16, reset to the SAP calendar with a $1,500 good bond. And position 17, reset further notice with a $3,000 SOB through the jail. Are there any questions, comments, or otherwise?
Just one question, Ms. Bridgewater. For number 5, it was $100 surety for positions 4 counts 1 and 2 and $200 for the rest, correct?
Charges 1 and 2 are $100 each good bond, and the rest of them are $200 each good bond.
Okay, got it.
Okay. Any others?
No.
Okay, great. Good job, guys.
Take care, everyone.
Bye. Okay.
Good
Judge,
job.
I'm sending the paperwork to you.
All
Have a
right.
good day, everybody.
Okay, bye-bye.
Thank you.
Bye-bye.
Bye-bye.
Okay.